In Masson v. New Yorker magazine, the court considered how the New York Times actual-malice standard applies to quotations attributed to a public figure. Jeffrey Masson was a professor of Sanskrit and a psychoanalyst. Sigmund Freud's daughter, Anna, hired him to be projects director of the Sigmund Freud Archives. After he accepted this position, Masson became disillusioned with Freudian psychology. He shared his new opinions at a public lecture. The Freud Archives fired him. New Yorker writer Janet Malcolm interviewed Masson for an article on his relationship with the archives. They met in person and spoke on the telephone several times. Malcolm wrote a long article based on these interviews and other sources. The article included long passages in quotation marks that indicated statements made by Masson. When a fact-checker called Masson to confirm the facts in the article, he was startled by the errors in his statements. He asked to review the article, but said he was brushed off. The New Yorker published Malcolm's piece as a two-part series. The next year, Alfred A. Knopf published the entire piece as a book entitled In the Freud Archives. The book portrayed Masson as mean-spirited and arrogant. Masson sued the New Yorker for libel, claiming that Malcolm fabricated the quotations attributed to him. Because Masson was a public figure, he had to prove that Malcolm published defamatory statements made with actual malice. The court compared several excerpts from the book to Malcolm's recordings and found that they were different. But it concluded that the inaccuracies were either substantially true or rational interpretations of the conversations, and they didn't amount to actual malice. It granted the New Yorker summary judgment. The Ninth Circuit affirmed. The United States Supreme Court granted cert.